All right. Hello. I wanted to welcome everybody to our webinar number 20. Today we have Mr. David Harty here speaking on probate and ancillary. Whenever you're ready.
Good afternoon. Today's discussion will be about the perils of probate and how to handle or create ancillary documents. And there's a reason I call it the perils of probate for those of you who've never been involved in a probate. There's the agenda. Getting started, first warning of trouble, problems that arise, removing a personal representative. Feel free to post questions. I like it interactive. I want to make sure that somebody's paying attention and I'm answering their question. Probate is a mixed blessing for attorneys. I know a lot of attorneys like probate because, let's face it, that's where you can make money. That's the only reason to like probate if you're an attorney. It can be a headache. You deal with fighting family members, disgruntled heirs, a court staff that can be unmotivated depending on where you are, and varying laws based on jurisdictions. Here's an example. Well, that's a little ridiculous, but a codicil be read on Jerry Springer. I have had cases where people have threatened each other's lives, their family members, over the probate, over wills, a lot of denial. So to the extent you're an estate planner, if the client has assets that are significant to justify a trust, it's usually a lot less contentious to settle a trust. I say usually because there are cases where people go for it and argue anyway, but it's much easier to handle a trust ordinarily. To get started, and this is based on experience, have a clear retainer agreement with hourly rates explained and set out. There's nothing worse than you get through probate and you present your bill. I know it's going to cost that much, and you charged me every time I emailed or called you or texted you. Yes. Well, I just wanted to talk. You're the attorney. I talked to my wife. I talked to my children unless they're asking for money. But you are not a friend of mine. You have to pay to talk to me. They'll use up your time all the time. So, and get a healthy retainer, significant. You'd be surprised. There'll be unexpected expenses that may, publication. For example, here in Maryland, one publication in one county might be $60, another might be $300 or $400. I don't know where you are in the country, but publication can be expensive. Bond can be expensive. If you have a designated personal rep, well, mom picked her, but they got a credit score of 380. Well, bond is often dependent upon a credit score. So the bond's going up. Just like you have subprime mortgages, you may have subprime bonds. I had to do that. I asked the client if she had good credit. She said, yes, it was in the 400s. Let heirs and legatees know your hourly rate and that they call you for anything that comes out of their share. Basically, I only take calls from the personal rep. Occasionally, though, you will have heir members who insist on calling you. What I do is let them know from the very beginning they shouldn't call me, and if they do and I answer, it's coming out of their share. And amazingly, I very rarely get phone calls anymore from other heirs and legatees. I'm involved in another case in another state representing one of 16 subfamilies. A little history. No will. The landowner died 100 years ago. It's Virginia. No probate was ever done. Virginia has a unique law about property dropping like a rock. Now they sold the property, and there's 16 subfamilies, up to 110 members in those subfamilies. And apparently the attorney who's handling it, I'm only handling one of the subfamilies. The overall attorney, the third one because the first two fired them, he's allowing people to call him. And I warned him, you don't do that. Bill them because you can't get any work done. So that's why it's critical to have a well-written retainer agreement in case someone goes to the bar to complain on you. Why is it so much? Keep your hours and keep them abreast. I said run from families and friends because everybody will claim they want a family discount. Your deceased relatives, wives, cousins, mother says she's family. Stick to your guns. Obviously, if it's a sibling, you may or may not discount. You may not charge them. But as far as friends, people never appreciate it when they get a discount. They seem to value you based upon what you charge them rather than based upon what they should have been charged. Often you'll get a call in probate. My so-and-so just died. When? This morning. I want to know what to do. And I advise you to offer your condolences, of course, and just tell them that they might want to focus on the funeral and settling those affairs, as far as arranging the funeral, but call you afterwards and after they have the death certificate. Because guaranteed, it's a very emotionally trying time, and they're going to forget 80 or 90% of what you told them anyway. Well, I'm ready to start probate. Insist that the person who will be the personal representative search the home of the deceased to find key documents. It's amazing how many times people will say, well, I don't know if they had a will. Have you looked? Well, no. Why not? Well, I'm busy. Well, you have to look, because if we open probate and say it's intestate and then we find a will, we have to start over again. If we don't know the bank accounts that they have on a property, we have to start over again. Something I always do, if there's land involved in a probate, I pull the deed first. Why? Because you'd be surprised how many times people think that their deceased loved one owned property, and they don't. They had signed it over, and you go and start probate, and you pull the deed, and there's a life estate belonging to someone else. I've come across cases with other attorneys where they haven't. I had one some years ago where they were telling my client that she had to get up the house because he had left the house to his nurse under suspicious terms. And the other attorney was rather nasty and adamant until I pulled the deed and just told me he was sloppy, because he read the deed 20 years before. The man had a life estate deed and left it to his own daughter. And he hemmed and hawed and apologized. I suspect he tried to pull a fast one. I don't know. But if you are the attorney handling the case, pull the records yourself. Do not rely on the client. They will tell you, well, lady hired me or wanted to retain me recently to create a trust. And I pulled the deed and realized, ma'am, you already have a life estate giving it to your son. You don't need to do the trust in this particular case. You can do a will and transfer on death for your bank accounts. But she didn't even know what she signed years ago. First warning of trouble. This is a simple probate. Folks, there's almost no such thing as a simple probate. The last simple probate I had was referred to me by a so-called friend. They didn't realize how bad it was. The lady had a holographic will that was Jabberwocky. In fact, the first thing I told the judge at a hearing was, I didn't write that. And he said, I'm glad to hear that. That probate took 4.5 years, because someone who lived in a house in D.C., you can be a common law spouse, claim to be common law. So if you hear someone tell you it's a simple probate, do not accept it or believe it. Gather the facts yourself, especially when it's a self-written will. They're often defective. Often. I think the classic one is, I've talked about all the time, where the person has a template. I gave the person a template. They said they knew what they were doing. Years later, I saw the will. They were still alive. It said, I state your name, hereby appoint, state your name as personal representative. I leave my assets to state your name. It was signed, witnessed, and notarized. So check the wills yourself and make sure they're valid. I have one now. I'm getting a call in the District of Columbia where the will would have been valid, but they only have a copy. They can't find the original. And in order to get it, well, I think DC doesn't like to admit a copy of a will. And there may be a way to get it in if all the heirs sign off and agree, but the children were disinherited. So that's not going to work. Here's something you'll get. I started to handle probate myself, but I got stuck. Do I get a discount? Always answer no. No, you don't get a discount, because you usually have to undo what they did, and it ends up costing you more time and them more money. In fact, be very careful with these so-called discounts. Please give me a total price before we begin. For those that you heard before, HTTN, hell to the no. You cannot give anyone a total price before you begin because you never know what's going to pop up. It's just don't do it. And occasionally you'll get some, well, I'll go someplace else. Bye, Felicia. Go someplace else. Because an attorney that gives a fixed price before they handle probate is looking for trouble. A will leaves real property to multiple family members. This usually ends up in fighting, and that's the truth. There's always one family member, or often one, who thinks the house is theirs because their siblings have done well and they didn't do well, it's their fault. And therefore they should, or they want the house, so therefore they move in and think it's theirs. And especially if they are listed as an owner, then evicting them is a major issue. You can't do landlord tenant because they're an owner. So you actually have to go to court and maybe a writ of detainer. I don't know what your jurisdiction is, what rules they have in each jurisdiction, or maybe file for wastage of property, that they're diminishing the value of the property by staying there, and get them charged for the fair market value of the rent, their share of the rent, since they are co-owners. So if someone comes to me and says they have a will or a trust and they want to leave the property to multiple family members, I strongly discourage them. And usually 85%, 80-85% of the time, I'm able to convince them this is a problem. Occasionally, you have the stubborn person, well, I just want to treat my kids equal, and then they die, and then the responsible child or heir or beneficiary is now upset because their trifling brother or sister or cousin is in the house, and they have to get them out. The will appoints co-executors. Gridlock often results, and some banks will not open an estate account with multiple executors. I have reluctantly agreed to take on a case recently. Though there was no will, but these individuals, for some reason, went and three of them got appointed as personal representatives. By the time I got called in, I happened to say, why'd you do that? That causes a problem. We know, Mr. Harty, we can't open an estate account. The banks are refusing. There's not a single bank they've gone to that will allow them to open an estate account with three executors. I have an accounting that's overdue. I'm trying to get it in because they retained me late. I looked at, they were using a family bank account and paying personal bills out of it. And so I insisted, though, that if I help them, two of them need to withdraw as personal rep and get an estate account open. But when you see co-executors, beware, you may have problems. And that goes for co-trustees also. I strongly emphasize that in creating these documents, try the best you can to convince them not to do co. Occasionally, I will have a client who says, well, I'll go someplace else. And I simply say, that's fine. No problem. My family will not fight. As soon as they tell me that, I pull my hair out. And you see, I have them. I've had cases with threats against the personal representative. I just got a call from a client. Well, she's not a client. She's a friend. I'm helping her in another state. And she's saying how violent and crazy her family is. And I said, well, they're not the worst. At least they've been threatening each other. And she said, no, actually, one's threatened to shoot me. I've had cases where we had to get restraining orders from family members because the will ordered the property sold. And this person, it was my mama's house. I grew up in it. Your mama wrote the will. Well, I don't know the will because I wasn't there. You weren't supposed to. It was none of your business. And they ended up threatening the brother, and we had to get a restraining order. Challenges to the personal representative by family members, anger with the attorney. Yes, I actually use a UPS store address now for my mailing address. They've shown up there a few times looking for me. I think it's hilarious, and so does the staff. That's not my office. You only know my office if I want you to know it. Wow. Why'd you hire that person? I know somebody, my friend, whose son sweeps the floor at the barbershop where attorneys go. He knows all about probate. Or my cousin handled probate and they didn't go through it. They have no idea what's going on. Well, no, my uncle's probate, we didn't have to go through probate. And I'm pulling it up during the workshop and looking at the probate going on. So be careful with clients, family members. Be aware these things happen. People, when you create a will, and if you're creating a will, I always ask who you're appointing and what's their credit situation. Why do you need to know that? I didn't ask their credit score, but are they financially responsible? Because in many jurisdictions, bond is based upon your credit score. And if you appoint someone, or if there's no will, even worse, because a will at least can say no bond necessary. But if it's intestacy, which most cases are, and the one who comes forward has bad credit, I'm in court and I turn to the client and say, "You have good credit, right?" "Yes." "It was 400 something." Ugh. The representative claims they have no money for a retainer. Get the retainer. Get a retainer up front. You cannot advance your funds. And what people don't have money for, they suddenly have money for if it's something they want to do. Here's my favorite. I want to check around for price. Will you match? Buy and don't come back. Because the client who starts off that way is going to drive you nuts later and complain about everything you do. I just got a call, another case. The client's angry, telling someone else that I'm taking too long and why they refer him to me. And of course, I couldn't tell her that he went and stole $40,000 or $50,000 of the family's money and gave me stuff with no records. That's why it's taking so long. People only tell half the truth. But do not get into a price matching thing. Set your price. Don't worry about what someone else charges. You know the value of your work. First warning of trouble. Again, family thinks the deceased was wealthy. I get a call, and mom had no bills. This is a real case. $169,000 of bills. Now, 101 was for a property in another state, and I don't know why they filed because of attached to lien, so I had to disallow it. But they had transferred title of the home the mother she's had to a third party, but not the mortgage. The rest were credit card bills, $68,000. I was able to get it down to 65% of that. And then you have the family expert, the family member who, I know probate, they're a librarian or whatever they are. I'm not knocking librarians. I'm saying, I tell people all the time, stay in your lane. What group seems to want to give the most advice to their members? Ministers. Don't ask me why, but they're experts on everything. And they'll say, my ministers say, and I'll say, the minister's on the pulpit, I'm in the courtroom. I don't tell him how to deal with your soul, and he's not to tell me how to handle law. I tell people, if you start going on YouTube and trying to be a lawyer, did you go to law school? Have you used the bathroom in a law school? Stay in your lane. Stop being a YouTube lawyer. And for those of you who don't know me, I really do say these things because you have to cut it off in the beginning or you will go crazy and have problems later. You are the professional. You are the individual. And if you don't know what you're doing, then get help. But you can't let them know that let them think they know more than you do. They can give you advice. You can look things up or ask you questions. But well, I read somewhere, I cut people off. Probate is stressful enough not to get involved with that. Problems with probate, and this is common. The personal representative distributes assets prematurely and there are debts to be paid. I have one now. She hasn't gotten back to me. I strongly suspect that she took money out of a bank account and distributed it. I said, but you haven't even done publication yet. I tell clients from the very beginning, I want to see every bank account from day to death, maybe a month or two before if I can, and do not pay any bills without clearing it with me. Because you're the one who has to explain to the court, what's this expenditure? And how could the deceased have ordered pizza 2 weeks after they were dead? Family member is living in the house and refuses to move out. Feels entitled because they're broke and siblings have a place to stay. Parents have disabled the adult by enabling them. Very common. Well, I feel sorry for him. When I die, his sister will put him out. That is so unfair. They duck the problem. And I don't know how many of you handle it, but often you have to go to court and evict the family member. And they're standing there screaming, hollering, it's my mama's house. I came home to take care of mama. You've been home 30 years. You're 55. Haven't lifted a finger to help mama. She's been dead now 18 months. You haven't paid the bills. Why haven't you gotten a job? So you have to go to court to evict. But during this period of time, the mortgage has to be paid. Where's the money for that? Many people are house rich and cash poor. I tell my clients when they call me, the first thing you do is change the lots of the deceased, of the home of the deceased. Because if not, things walk. And if there's a will in there or a trust in there, and somebody finds it and doesn't like it, it will vanish. Classic case I had here a couple of years ago, the lady had done a trust in 2015, 2016, and amended again in 2017. She had 2 adult daughters. In 2015, it was 50% each for the daughters, but she had a falling out with one of the daughters. So by 2017, it was 25% for the 2 daughters and then 25% for 2 granddaughters. The oldest daughter, who she had problems with, for some reason, she still let her be the personal rep, but not the trustee. She ran to court with the 2015 trust, claiming 50%. I was retained by the granddaughters because they knew me, and she denied ever seeing the 2017 trust. So we're in court, and her lawyer, is very pompous and letting them know that she hadn't seen it. She's testifying. So I put her sister on the stand, and I asked, has your sister ever seen the 2017 trust? Yes, Mr. Harty. Well, why? When she see it? We all were sitting around the kitchen. Well, what were you doing? Mr. Harty, you were sitting there explaining to us. Real story. I had not created the trust, but I knew a lady who's a neighbor. Her lawyer did not know that I'd seen the trust. The judge stopped the hearing shortly thereafter and removed her as trustee. But this is an example of when you're creating an estate plan for someone, convince them not to pick someone just because they're oldest, and not to pick someone, don't worry about their feelings because they'll be dead, so it doesn't matter. But pick the person who's honest and will follow their wishes. Sometimes the personal rep does not communicate or follow through with you as the attorney. It's very difficult. Then they want to know why you're missing your deadlines. When I create a trust or a will, I advise the client very strongly, if they have a trust, to make the bank account, put the bank accounts in the trust, and make the bank account of the trust the beneficiary of the life insurance. They often don't listen. And let's say they leave 50% to the kids, each kid, and there's always one child who will pay the bills, the funeral bills, and the other one won't. Now you have a problem how you pay mom or dad's funeral bill. A lot of these problems that arise would be avoided if things were handled ahead of time. Of course, you can't always pick your clients. So I'm making you aware of issues that will arise. Then you get the phone call, the anger. My mama promised this to me. My dad promised to me. It's not in writing. I don't want to hear it. Well, you're very callous. And even established attorneys, especially who specialize in other areas, will say, well, but I told them what I want. I don't care what you told them. It must be written down in a manner that complies with local law. That's all. An heir or legatee wants their money now. I need my money. Why? Well, because I bought a Land Rover. When did you buy a Land Rover? After Dad died. I didn't tell you to buy a Land Rover. And I advise the executor or trustee, do not distribute those funds to the appropriate time. Well, they need it. No. Heir or legatee signs away their share with advanced probate. Now, I'm not here to malign just advanced probate. I mean that generically, although there's a company called Advanced Probate. I did a trust, I don't know, how many years ago? 15 years ago? She's now deceased. And her adult son, who's an attorney, called me up and wants to know if I would sign off on allowing the trustee to pledge his share of the money in exchange to, for advanced probate. No. A, you haven't retained me, and B, the trust specifically says you can't do that. Just be aware about that. Family members call a register of wills or orphans court to discuss the case with staff and then try to educate you. Don't take their calls. No matter how many times you tell people they think they know more, do not stress yourself dealing with wannabe lawyers. A lot of times people will create wills and file them and have no idea what they've done. And they blame you. They did it. But I thought, well, I wasn't there. I didn't do the will. Again, these two things I reiterate, only speak to the person representative, not the whole family. And multiple person representatives, the bank may refuse to open an estate account. I mentioned this a little earlier. Family member destroys the will they don't like, lies about not seeing it, tries to steal a car, then denies driving it. Trustee simply steals family members' inheritance because the family is broke and cannot afford a lawyer. This is a case where you may have to take an action to remove the executor or trustee. It's a real one. This one was the cupcakes. An individual was referred to me, didn't have any money as a favor. I said, I'll do the paperwork, not for a trust, something different. And your friend has designer cupcakes. You bring enough cupcakes for a picnic, and this little minor thing will happen. Then find out later on that her grandmother died, and the house, she thought the house was supposed to go to her mother, who's deceased, so therefore her. She confronts her aunt, who laughs at her and tells someone she's broke, she can't afford anything. You never know who knows who. I took a liking to the situation, to her, didn't like the situation, took action, had the aunt remove this trustee and pay my legal fees. So be kind to a duck. He might be somebody's mother, but most importantly, even though I do not believe that you should let, that the client should let the family know everything in their will or estate plan, I do believe that they should let them know one exists and it's to be filed, and let the person who is the personal rep or trustee know. I jump around. Probate can be lengthy. It can be expensive. Keep thorough track of your time and expenses, and I'm not the best at that. People always get convenient amnesia as to how many times they called you or contacted you. And well, you shouldn't have charged me for that. Keep a good record. Probate is, again, for those of you who make their living doing it, I know you can make money. It's no question. But I just don't like it. At this stage, I'm trying to get out of probate. But if you're starting a practice, learn the rules about probate, because you can at least pay the bills. And you're helping people, don't get me wrong. Living probate, ancillary documents. And for those that have questions, go ahead and put them on the chat. Medical directive and medical POA. I tell people if they don't even have a will or a trust while they're alive, the medical directive and the powers of attorney are critical, because you do not want to be in the hospital and you're unable to communicate. And it's always going to be the friend or relative you do not want speaking for you that volunteers to give their opinion. Always happens. And even when you have it in writing, I've seen instances where people have gotten almost violent, yelling at each other. You want to be cremated and you want DNR or DNI, and the other person doesn't believe in it. DNR, for those of you who don't know, do not resuscitate. I'm sorry, yes. And that one people are aware of, but the fighting is often over DNI, do not intubate. You are unable, the gag reflex is gone. You can't eat food. Do you want to be intubated? Down the throat, nose, stomach. Most people say no. If I am end stage, terminal, or vegetative, let God handle it. And you get the ones that say, well, no, I believe that God's a miracle. My response is, if you believe God's a miracle, then pull that plug and let's see if God saves them. They don't just, if you're in a proper area of quality medical care, they don't just jump up and say, hey, we're going to pull the plug. They run the tests multiple times. And then the person you have designated in your document is the one you want to make that call. I went in for my when I became eligible for Medicare, yeah, I'm old. The nurse asked me if I had a medical directive, and I just happened to mention, yes, I do it for a living. And next thing I got 3 or 4 new estate plans to do, because she was looking for someone to handle it. But you want to know in writing, you want to put in writing, do you wish to be resuscitated? You are the client. You want to explain to the client if you're end stage, vegetative, or terminal, and it's a quality of life issue. I put down prayer warriors versus God's will, because sometimes people want to say, I want them to pray for 10 days over my body. Well, they're the client. You try and explain that. But I said, but if God's will wants them to survive, they will. Give them proper medical care as much as possible, to the level or to the degree where it is not going to help. Do you wish to sit there vegetative and just being a burden on your family? It's a question I ask. And that goes to blood transfusions. The client should not name the medical power of attorney, the designee, who opposes blood transfusions, especially on religious grounds, if they want a blood transfusion. Now you have an issue. Make sure the person you name is someone who will follow your wishes, someone who can spend time at the hospital or nursing home wherever you are, because you name someone across the country you can find every 3 weeks. Let's face it, many times the staff at certain places, health issues, hospitals or nursing homes, etc., rehabs, aren't the highest paid. And we have found that the quality of care, like anything else, often depends on who is there to advocate for you. And you want someone who can advocate for you. If you name your favorite niece who has 3 kids and lives in California and has to work all the time, they can't stay at the hospital driving people crazy. My mother was a retired nurse, and when my wife was in the hospital, she took over a wing at Johns Hopkins, drove them nuts. By the time she left, they loved her. But my wife got proper care, quality care. Provide a copy to all medical providers. When you start going to the doctor, give them a copy of your medical directive and medical power of attorney so they can scan it in. Do not name elderly person if you are old. So the 92-year-old who wants to name, I forget the name, she named someone, and I said, who's that? My 88-year-old sister. Not a good idea. She's getting old as you are. You're aging as she is. Name someone. Now, I'm not saying not to name your mother. Don't beat me up. And I'm not being anti-old, but I think if you're over, I can say it. Don't name someone who's starting to fade. An individual would call me and tell me she did not want her mother in charge. She loved her dearly, but her mother's older and was starting to lose it and very determined. So she was not named, and then the lady died, and the mother wanted to take over. The nephew, her cousin, was in charge, and he was afraid of his aunt. Finally, I just said, go somewhere else, because I was not going to deal with the mother when the daughter told me not to. And having met the mother, I knew why she told me not to. So they went somewhere else. There's good money, there's bad money. You don't need bad money. Financial power of attorney. Name the most responsible individual, not necessarily the oldest. Name an individual with similar assets and mindset. What do I mean? If you have amassed any type of wealth or property, don't put your brother or sister who can't make ends meet, who gets paid on the first, is broke on the third. If you have small children, don't name as the guardian your sibling who has small children and is broke, because everybody's going to Disney World, and they're not going to put your child in the private school you want them to go if their child can't afford it. Make sure your power or financial power of attorney designee has access to your passwords. That's one of the major things I'm coming across now, both in financial power of attorney and estates, because everything's done on the internet now, and we can't get into the computer, and nobody knows the passwords. Cash App and the other ones, something pay, I forget what it's called. Those, the Bitcoins and the internet funds or bank accounts, you need the password. Otherwise, you have to go and get a court order and then find out they only have $5 in it anyway. So you really want to be careful with that. Now, as opposed to the financial power of attorney, or medical power of attorney, I would not give a copy of the financial power of attorney to your designee. Remember, power of attorney with financial, they can go ahead and access your bank accounts right away. I wouldn't do that. I would not do that. Medical, you give it right away because they're not, they can't overrule you. With a medical power of attorney, if you're able to communicate, then the medical professional will speak to you. But with financial, the lady hired a lawyer, of all people, and in her POA, she was able to open a joint bank account and took her money. So she had to retain me to get the money back from the lawyer. And most important, keep a list of all your account information and passwords in a safe place. Let someone, usually I tell people, do not use a safety deposit box, because even though they're not supposed to, they're often frozen at death by the bank employees. Now you need a court order only to find out the box is empty anyway. But a good solid home safe is often a good idea. And, our eyes fade as we get above 40. And so you might want to get a biometric one or with passcodes. We play a critical role in guiding and supporting the executors. Make sure it's done properly. Mistakes are costly. And as an aside, let's encourage our clients the best way to avoid probate litigation is to plan ahead. Again, with probate, we don't know the client before they die. We didn't know their deceased person, so we're stuck with what is handed to us. Just be careful, because while probate can be lucrative, you can get a lot of complaints. People are often never happy with what they get. The lady dies, she left everything to a friend. The friend said, I'm going to give every one of the deceased siblings who's alive 25,000. So she gives us 25,000, and what do they want to know? Wow, if she gave us that much, what did she get? It's none of your business. Or my daddy had another insurance policy, and I don't know who the beneficiary is. I called the company, and they said someone's name. I said, so it's none of your business. Well, I need to know. Why? Well, it's my daddy. Your daddy was divorced from your mother for 40 years. He may have another young thing. But, I'll fight that. How are you going to fight it? And this is from a person who's an attorney. People, be prepared for everything. It makes your life easier. Any questions? Well, I guess I bored everybody, Charlene.
Yeah, I'm not currently seeing any active questions right now.
Yeah.
Go like this and give it a moment to see if any trickle in real quick. Jeff Marsacci says, excellent information and great stories.
Well, thank you, Jeff. Okay.
All right. Well, thank you for speaking today, and thank everybody for joining. I think we'll wrap it up here, and we look forward to seeing you next month.
Thank you.